Calls to order. Begin with the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And anybody who's going to give testimony today, if you just stand where you are and raise your right hand, and I'll swear you in. Do you swear from the testimony you give is the truth, the whole truth, and nothing but the truth? I do. Thank you. For the respondents in the audience today, my name is Drew Smith. I'm the Code Enforcement Special Magistrate for the city. I am not a lawyer for the city. I am a trained lawyer, but I am not a lawyer for the city. My role in these proceedings is to be an independent fact finder. The way we'll proceed today is we will hear the cases as in the order they are in on the agenda. The city will present its evidence and testimony first. If you have any questions for the code enforcement officer, you will have the opportunity to ask those questions, and you will also have an opportunity to present to me any evidence and testimony you would like me to hear or see. Once I reviewed all the evidence and testimony submitted to me, I will render a verbal order on the hearings today. That will be followed in the mail by a written order that you'll receive probably sometime next week. And with that, clerk, you may call our first case.
I think they went to the third one because she was present.
Are we taking them out of order? Are we taking them out of order? Which case do you want to have first?
Case number 21522.
The
Okay,
third
you
one.
can call that one.
Case number 2021-522, Elizabeth Wolf, owner, location of violation, 215 Illinois Avenue, St. Cloud, Florida. Violation, St. Cloud City Code, Section 24-162A. Description of violation, failure to prohibit but rather allowed grass and weeds to be above the height of 8 inches.
Good afternoon. Alex Miller, Code Enforcement Officer for the City of St. Cloud. I'm presenting the case for the property located at 215 Illinois Avenue. At this time, I would like to enter into evidence the following items. Copy of the courtesy notice sent by regular mail. Copy of the notice of violation sent by regular mail. Copy of the notice of violation sent by certified mail. Copy of the statement of violation and notice of hearing sent by certified mail. Copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, copy of the sections in violation, a copy of the deed to the property, and a copy of the costs incurred if the magistrate finds the respondent in violation in the amount of $234.90. And the respondent is here, and I have provided with the copies of the case. On March 3rd, 2021, during routine patrol, I observed the grass weeds to be high at this location. A courtesy notice was sent to the owner to correct the violation within 7 working days. On March 18, a reinspection was performed and verified that the property was still in violation. On March 22nd, a notice of violation by regular mail was sent to the owner to correct the violation within 7 working days. On April 2nd, a reinspection was performed and verified that the property was still in violation. A notice of violation by certified mail was sent to the owner to correct the violation within 7 working days. Posted the property in City Hall, created an affidavit of posting, and took 6 photos. On April 13, a reinspection was performed and verified that only the front yard was mowed and the grass in the yard behind the chain link fence was still high and in violation. On April 14, a statement of violation and notice of hearings was sent by certified mail to the owner. I posted the property in City Hall, did an affidavit of posting, and 4 photos were taken. On May 4th, a reinspection was performed and verified that the property was still in violation, and 4 photos were taken. On May 14, a reinspection was performed and verified that the property was still in violation, and 5 photos were taken. It is the city's recommendation that the respondent be found in violation of allowing the grass weeds to be over the height of 8 inches at this location. The city will also recommend that the violations be corrected by June 4th or pay a fine in the amount of $100 a day until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $234.90 to be paid within 7 days of the written order by the special magistrate. And this concludes my presentation. Thank you.
Okay, I don't have any further questions for you. Respondent?
Hello, sir.
And if you'd start by stating your names for me.
My name is Elizabeth Wolf.
My name is Reed Wolf. I'm her son.
Okay, thank you. You can proceed.
I'm aware of the situation in the house. My oldest son was living there. My father passed away September 29th, and I inherited his property. I moved to Narcoossee with the hopes that my son would take care of the house, which obviously he hasn't. So my youngest son has come back now, and he's here to help, to kind of resolve all this disaster that's come out of this here. If you could just, I think I have till June 4th.
That's what the city has requested, and so my question to you would be, do you think that gives you enough time to get the property taken care of?
I was just aware of it now, actually yesterday. That's what I was speaking to the lady over here, and I could have it resolved at least within the next couple days. I'd say by Monday.
Okay, so then June 4th gives you plenty of time.
Yes, sir. Yes,
Okay.
sir.
The other request the city has made is for the payment of administrative cost. Based on the evidence, I find that that's justified, and typically we would order those to be paid within 7 days. Does that create any hardship on you where you
No,
would
I
need
can
more
pay
time?
that today. That'd be fine.
Okay. Well, then, based on code enforcement's evidence and your testimony, I will enter code enforcement's recommended order. Order that the violation be cured by June 4th, 2021. I'd encourage you to let code enforcement know when you've taken care of it. That way they can come out and look. And if they see
absolutely.
any spots where something maybe got missed, they can let you know.
Absolutely.
Because if it's not brought into compliance by June 4th, then fines of $100 per day will run. Also order that the administrative cost of $234.90 be paid. That will be due within 7 days of the date of my written order, which will not be today. So when you get that order, if you haven't already paid them,
Okay.
that's when your clock starts ticking on those 7 days, okay?
Thank you
Okay,
so
thank
much.
you.
Thank you for coming.
Okay,
And thank you for
thanks.
taking care of the problem.
All right. Do we have any paperwork, anything else?
You'll get an order in the mail from me, so you don't need anything else today.
Okay. All right, thank you.
And I think the officer's going to give you Ms. Clocker's business card. She'll be the one that you'll make the arrangements to pay the administrative costs with.
Thank you.
Case number 2021-137, Robert and Clara Rivera, owner, location of violation, 2878 Harlow Avenue, St. Cloud, Florida. Violation, St. Cloud Land Development Code, Sections 3.3.1F and 13.3, Description of violation, failure to prohibit but rather allowed construction of a fence at this location prior to obtaining a permit.
Good afternoon, Melissa Howells, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: a copy of the courtesy notice of violation sent by regular mail, a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail posted on the property and City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, a copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $223.90. And I do not believe anybody is here on this case. On January 12th, 2021, during routine patrol, I noticed a fence up at this location, and a permit was applied for the fence back on April 23rd, 2020, but never obtained. On January 14th, a courtesy notice of violation was sent to the owners of the property, advising that the permit was never obtained for the fence, and they needed to notify the contractor of this and obtain the permit within 7 working days. On January 29th, I checked the status of the permit and it had not been obtained. On February 1st, I sent out a notice of violation advising the status of the permit and that the property was not in compliance, excuse me, and to obtain the permit within 7 working days. On February 15th, I sent out a notice of violation to the owners of record by certified mail. I posted it on the property in City Hall. I did an affidavit of posting, and I took 3 photographs. On February 25th, a reinspection was performed and the permit...
We've had somebody
I'm
come
sorry.
in. Let me check and see which case she's
Okay.
here on before you proceed.
That's not on the schedule, right?
Georgia, 221 Georgia?
No, Juliana. Georgia's here, right here. Continue, or,
Wait until,
okay. She's in compliance, she just needs to call for an inspection with the building department.
okay, you can proceed.
Okay.
Jack's paying attention again.
Okay. On February 25th, a reinspection was performed and the permit showed new paperwork had been submitted to the building department on February the 17th, so I extended the case out for 2 weeks. On March 25th, the permit still needed a notice of commencement and recorded easement agreement to be submitted. On April the 7th, the status of the permit was still the same. Tisha in the planning department stated that she even tried calling the contractor with no response. I then tried calling the homeowner from the number in the utility records with no answer, and the mailbox was full, so I could not leave a message, and no one has returned my call. On May the 3rd, after returning from vacation, which was almost a month later, the status of the permit was still the same, and there was no recorded notice of commencement or easement agreement on file. On May the 4th, I sent out a statement of violation and notice of hearing by certified mail to the owners of the property. I posted the property in City Hall. I did an affidavit of posting and took 3 more photos. On May 17th, I performed a reinspection and the permit had not been obtained. 2 more photos were taken. It is the city's recommendation that the respondent be found in violation of constructing a fence at this location prior to obtaining a permit. I would like to give the respondent until June 2nd, 2021 to obtain the fence permit or pay a fine in the amount of $100 a day until compliance is met. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $223.90 be paid within 7 days of the written order by the special magistrate. I have not had any response from the homeowners, even after
Is the home
posting.
occupied?
Yes, it is.
And this is more of a curiosity question, just because the photographs look very similar to photographs I've seen in other cases. Is this the same neighborhood where you've had similar issues with fences?
Yes,
Do you know if it's the same contractor?
yes.
It is the same contractor?
Mm-hmm.
You know you can name the contractor, right?
Osceola fence.
No, I mean, you know you could bring a case
Oh.
against the contractor.
Well, we've been writing citations, and, but I did not know I
You can
could.
deal with the city attorney on that one, but it
Okay.
is possible to either bring a separate action or
Okay.
name them in the same action.
Okay,
And
will
if-
do.
If the contractor is causing the problem, that might be a better solution than just continuing to have these cases.
Okay, we will definitely get with him.
Based on the evidence testimony in this case, though, I will find the city has carried its burden of proof, find that the property is in violation for constructing a fence without obtaining proper permits. Will allow the respondent until June 2nd, 2021 to obtain the permit. If not brought into compliance by that date, a fine in the amount of $100 per day shall run for each day thereafter. The property remains in noncompliance. Also order the respondents to pay the administrative costs incurred by the city in prosecuting this action in the amount of $223.90, which amount shall be due within 7 days of the date of my written order.
Thank you, sir.
Case number 2021-143, Luis Miguel Maldonado and Miramar Ramirez, owner, location of violation, 2962 Harlow Avenue, St. Cloud, Florida, violation St. Cloud Land Development Code, Section 3.3.1F and 13.3, description of violation, failure to prohibit but rather allowed construction of a fence at this location prior to obtaining a permit.
Melissa Howes again, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: a copy of the courtesy notice of violation sent by regular mail, a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, excuse me, copy of the notice of violation sent by regular mail posted on the property and City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $225.90, and the respondent is not here for this case. On January 12th, 2021, during routine patrol, I noticed a fence up at this location and no permit on file. On January 15th, making sure we're on the right screen here. On January 15th, a courtesy notice of violation was sent to the owners of the property to obtain a permit within 7 working days. On February 15th, I checked the permit records and there was no permit applied for. I then sent out a notice of violation by regular mail to the owners of record. On March 2nd, I performed a reinspection and no permit had been obtained. That same day, I sent out a notice of violation by certified mail to obtain the permit within 7 working days. On March 19th, there was no permit on file. On March 22nd, still no permit. I then created a notice of violation, sent it by regular mail, posted it on the property and City Hall. I did an affidavit of posting and took 3 photos. On April the 6th, I sent out a statement of violation and notice of hearing by certified mail to the owners of the property. I posted the property and City Hall. I did an affidavit of posting and took 4 more photos. That is a shot from the rear because I wasn't sure if they just put gates up, you know, when you have one house right after the other. So that is the rear of the property's fence. So they at least did more than just the two gates. On May 13th, while creating my presentation for the hearing, I checked on the permit records, and it shows a permit was applied for on April the 6th. On May 17th, I performed a reinspection, and the permit had not been obtained, and 3 photos were taken. Or actually, it was 2 photos.
Did you have any, did the record show any reason for why the permit was not issued?
No, on this one, it did not. I don't know why it took all the way to posting the property with the statement of violation, but it was a different contractor on this one that applied for it, so I'm not quite sure if, but there are people, they are living there. I mean, we have access to the utility records,
Let me
so.
make sure I understand the testimony. So the permit was applied for?
It was applied for, I went on vacation for 3 weeks, so between March 22nd, when I posted the property, on April the 6th, I sent out the statement of violation, and I went on vacation, and when I came back on May the 3rd, I checked, or on the 13th, I checked while I was doing my presentation, my PowerPoint, and it showed that the permit was applied for on April the 6th. So it might have been applied for after I posted the property, but they did apply for it, but they have not obtained it. They need more documentation. So it is the city's recommendation that the respondent be found in violation of constructing a fence at this location prior to obtaining a permit. Give the respondent until June 2nd, 2021 to obtain a fence permit or pay a fine in the amount of $100 a day until compliance is met. The city would also request that the cost incurred in bringing this case before the magistrate in the amount of $225.90 be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
Based on the evidence and testimony presented, I will find in favor of the city, find the violation for construction of a fence without proper permits did occur on the property, find that it has not been brought into compliance, allow the respondent until June 2nd, 2021 to obtain the permit or pay a fine in the amount of $100 per day for each day thereafter until compliance is met. Also order the respondent to pay the administrative costs in the amount of $225.90, which amount should be due within 7 days of the date of my written order. And just for that order, I want to make reference to the permit application to avoid any confusion when they get that. And so if you'd give me that date again, that your record shows.
Yes, it's April the 6th, and I have the permit application number with me. It is B21.
Is that a capital B?
Yes, capital B 21 dash, and then 4 zeros, 1763.
And does the record show any date on which that was rejected or denied or whatever? It just shows that it was not issued.
It just shows it was not issued and that they're waiting on, like the same kind of documents, notice of commencement, recorded easements, so forth, yeah.
Okay, thank you.
Thank you.
Case number 2021-721, Progress Residential Borrower 13 LLC, owner, location of violation 3809 San Adriso Circle, St. Cloud, Florida. Violation St. Cloud Land Development Code, Section 3.3.1F and 13.1. Description of violation, failure to prohibit but rather allowed a fence to be installed prior to obtaining a permit.
Good afternoon, Alex Miller, Code Enforcement Officer for the City of St. Cloud. I'm presenting the case for the property located at 3809 San Isidro Circle. At this time, I would like to enter into evidence the following items: copies of the notice of violations sent by regular mail, copy of the notice of violation sent by certified mail, copy of the statement of violation and notice of hearing sent by certified mail, affidavit of postings, copy of the PowerPoint presentation, evidence of mailings, copy of the code sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate find the respondent in violation in the amount of $248.10. The respondent is not here. On March 25th, 2021, during routine patrol, I observed a fence was installed at this location, and I verified there was no permit application on record with the building department. On March 26th, a notice of violation by regular mail was sent to the owner and registered agent on record to correct the violation within 7 working days. On March 26th, upon request, an email with a copy of the notice of violation was sent to Mrs. Walker, she is the resident services coordinator for Progress Residential, advising her of the violation, and she replied that the violation will be corrected. On April 7, I verified that no permit application has been submitted to the building department, and a notice of violation by certified mail was sent to the owner and registered agent on record to correct the violation within 7 working days. On April 23rd, I verified that no permit application has been submitted. A notice of violation was sent by regular mail to the owner and registered agent to correct the violation within 7 working days. I posted the property in City Hall. An affidavit of posting was created, and 4 photos were taken. Okay. On May 4th, I verified that no permit application has been submitted. A statement of violation and notice of hearing was sent by certified mail to the owner and registered agent on record to correct the violation within 7 working days. I posted the property in City Hall. An affidavit of posting was created, and 1 photo was taken. As of May 14, I verified that no permit application has been submitted and the property is still in violation. It is the city's recommendation that the respondent be found in violation of not obtaining a permit for the fence that was installed at this location by the time specified. The city will also recommend that the respondent be given until June 4th to obtain the proper permit or remove the fence, or a fine in the amount of $250 a day be assessed until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $248.10 to be paid within 7 days of the written notice by the special magistrate. And this concludes my presentation.
Is this in the same neighborhood as the other ones?
No, no, sir.
As for the violation, is there anything that makes this different than the other fences without permits that we've heard today?
Well, this is a management company that buys this property and then rents them out, and then they install fences without a permit. They do it all the time.
I'm asking because we've had 2 other fences without permits.
Mm-hmm.
The request was June 2nd for compliance date or $100 a day per fine. And if there's a basis for differentiating this case from that, I'm fine doing that. I just want to hear the enunciation of it. If it's substantially similar to the other cases in terms of severity and nature of violation, I will conform my order to what I've ordered the other cases that to me appear similar. So I'm looking for any testimony or evidence that this is either through repeated violations by the same company, which maybe is the point you're making, or severity of the violation. There's a reason to treat this one differently than the other 2 we've heard today.
It is a recurrent, can you, please, I'm
I
sorry.
just had 2 cases with the same company that I drug the cases out about 3 months, and, and we're still.
And I recognize the respondent, so I know that you've had
We're
cases
still having
before.
issues with them obtaining the permits before doing the work. So, after my 2 cases, then she got another one, and they should be on it. You know what I mean? So she asked me my opinion, and I told her to go for a higher amount.
So if I understand what I'm being told correctly, and just confirm that what I understand is correct, that this respondent
Correct.
repeatedly engages in the same behavior. They are on notice of it, and they have not yet
Yes.
corrected the behavior.
Correct.
Correct.
I brought the same
Pam,
one.
to go to the
Sorry.
I brought the same one. The only difference, it can't technically be a repeat because their name is a little different, but it's still, like the end of it's not usually 13 LLC, but it's still Progress Residential.
And while it is a different company, I did notice that the principle and the service is the same, so.
Yes.
You've made the showing that I was looking for. I just wanted to make sure that I was understanding correctly, that there was a reason for the different requests. Based on the evidence testimony presented, I'll find in favor of the city, find the respondent is in violation for causing or allowing a fence to be installed on the property without a proper permit. Allow the respondent until June 4th, 2021 to cure the violation. If not cured within that time, a fine of $250 per day based on testimony regarding prior circumstances of this respondent. If not brought into compliance, $250 a day, be assessed until compliance is met. Also order the respondent pay the administrative costs incurred by the city in the prosecution of this case in the amount of $248.10. That amount to be due within 7 days of the date of my written order.
Thank you.
Case number 2021-1016, Diamond Homes LLC, owner, repeat violation, location of violation, 1106 Oregon Avenue, St. Cloud, Florida. Violation, St. Cloud City Code, Section 24-162A. Description of violation, failure to prohibit but rather allowed the grass and weeds to be over the height of 8 inches at this location.
Good afternoon. Pam Neal, City of, what? It is. Excuse me. Good afternoon, Pam Neal, City of St. Cloud Code Enforcement Officer. I am presenting this case for the property located at 1106 Oregon Avenue. This will be the third repeat violation for the same, the grass and weeds. At this time, I would like to enter into evidence the following items. Copy of the statement of violation, notice of hearing, sent by certified mail to the owner and posted on the property and City Hall, copy of the PowerPoint presentation, a copy of the affidavit of posting, the certified mail receipt, a copy of the deed to the property, a copy of the code section in violation, a copy of the costs incurred if the special magistrate finds a respondent in violation in the amount of $218.45. On May 7th, 2021, I received a complaint about high grass and weeds at this location. So on May 7th, I went to verify the violation. I took 8 photos. On May 7th, a statement of violation and notice of hearing was sent by certified mail to the owner, posted on the property and City Hall. An affidavit of posting was completed. On May 17th, a reinspection was performed, and the grass and weeds were still not mowed. I took 4 photos. And the respondent is not here today. It is the city's recommendation that the respondent be found in a repeat violation of allowing the grass and weeds to be above the height of 8 inches at this location, and to pay a fine of $500 a day starting from May 7th, 2021, the day the violation was found, until compliance is met. The city would like to also recover the cost incurred in bringing this case before the special magistrate in the amount of $218.45 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
You stated this is the third
Yes, sir.
violation. The prior 2 have all been brought before me and order entered. Do
Yes, sir.
you remember the date of the most recent?
I don't have I think it was,
I recognize the respondent.
yeah, I think it was it last month?
I think it was 2 months ago.
What's that?
2 months ago, I think.
Yeah, 2 months, that's what I thought. I'm sorry, I should have had that information for you.
I recognize the respondent in the violation, so I don't question whether or not it's a repeat. I just wanted to have correct in my head the recency of the repeat. Based on the evidence testimony presented, I will find that this is a repeat violation for grass and weeds over the height of 8 inches on the subject property. Order the respondent to pay a fine in the amount of $500 per day, which fine shall begin to run from the date of first observation of this violation by the code enforcement officer, which date is May 7th, 2021. And order those fines continue to run at the rate of $500 per day until the violation is cured. I will also order the respondent to pay the administrative cost in the amount of $218.45, which amount will be paid, shall be due within 7 days of the date of my written order.
Thank you.
Well, so when I send you that order, I will send it to you before it goes to them, because you'll certify it, and that, the same order that I send you will be the one that you record.
Okay.
You won't get two on this one.
Okay. Unfinished business, case number 2020-1809, Great House Pros, Inc., owner, location of violation, 500 Wisconsin Avenue, St. Cloud, Florida. Violation, Land Development Code, Section 3.3.1D. Description of violation, failure to prohibit but rather allow 2 permits for this property to expire at this location, with work already started, with only 1 inspection completed between both permits.
Hi, that's my case. I did check it today, and he applied actually on the 12th of May, but he got, it got disapproved on the 19th. It got disapproved actually this morning, for he only turned in 2 of the 8 sheets that were needed. And he did call me on the phone. I guess it took him until the 12th to get the contractor. He had to go up to where the contractor was and actually have him fill out the paper there. And then he took it to the building department, so he told me it actually took him that long. And I tried to get the permit to be rushed through, but it was disapproved, so he didn't turn in all the paperwork anyway. So.
Okay.
That's all I have.
Okay.
Thank you.
Reduction of lien over 50,000, case number 2017-296, Myra Salami, Kathy Smart, Janie Palmer, Mary Holloway, owner. Location of violation 4403 Brave Lane, St. Cloud, Florida.
Good afternoon, Jack Morrison for the city. This is the first of 2 requests for lien reduction matters regarding this this property. The first of which, Mr. Magistrate, is dealing with an accrued lien that exceeded the $50,000. So this would be a recommendation to the council, as you know. And I would point out, there's a letter in you should have a copy of the letter from Ms. Smart, one of the respondents from this property, dated April 14th. The letter goes into some detail about some of the hardships that the family has encountered. But essentially, at the culmination of the letter is a proposal to come up with the administrative costs. It's absolutely not acceptable to the city manager. The city manager has submitted an acknowledgement, or what his position would be in terms of a recommended resolution amount for this property. The accrued lien exceeds $90,000 for essentially an unmaintained and overgrown landscaping violation, which went on for some time. Compliance was ultimately achieved after a couple of years. The total amount of the fine is $94,472.20. The amount with which the city would consider accepting a resolution was about just a little bit over 10% of that amount. $9,602.20, which would include the administrative costs. We don't have an agreement with the respondent. I would just point out, there's not a signed agreement. I've not spoken with any of the respondents. We simply have the letter of April 14th, which I think is what prompted the city manager to submit this city position in terms of what the city would consider. So it's a little bit unorthodox. Typically, we bring to you an agreement, but because we felt compelled to respond, that's where we are with regard to this.
Okay.
Okay? And I don't know that anyone's here.
Yes, I'm supposed to be here as her
Oh,
realtor.
you can
I
come up.
don't
You
really
can
know what to
go
tell
ahead
you.
and come up and identify yourself, and you can speak to the magistrate and just. Sure.
Hi, I'm Margetti, and I am a realtor, and I do live in Tika Village. She called me last night, and she said, they told me I should have somebody there to represent me. So I am here. So other than, I can only tell you, I know that there is no way that she can come up with this kind of cash or money to take care of these things. So anything we can do to reduce this would be very, very beneficial. Maybe eventually they could get the lot itself sold. But right now, we can't do anything with it.
I'm not doing anything with that, city manager.
So,
Okay.
okay, other than that, I don't know what else to tell you.
All right, that's fine, that's fine.
Okay,
Um,
thank you.
We actually had a discussion on this the other day, so.
Well, but here,
Hold on.
yeah, candidly, the city, there was some discussion about getting this resolved, potentially at an amount which was less, was a significant even discount off of the amount that I have, but I only have what I have from the city manager, excuse me. I have what I have, and I'm not authorized to go above that. So for
Understood.
purposes of today, we have the city manager's May 13th suggestion, which is marked out at 9602.20 as the city. I think the city, that's the position of the city.
Actually, I have a question for the realtor, if you wouldn't mind coming back up, ma'am. Sorry to make you come back up, but I'm making an assumption here, let me make sure that it's accurate. Is the property up for sale as?
Not yet.
Not
We
yet?
have not been able to do anything with it until we get these things resolved.
Do you think, and I'll let the city weigh in on this concept too, do you think would it be helpful in getting that property listed if the fines are reduced, and time is given to pay them? Normally, the city would ask for, and I would recommend or approve, depending on the circumstances, a reduction, but that would have to be paid within 30 days. There's nothing written in stone that it has to be that way, so if we were able to do a reduction, or I cannot grant it today because this does have to go to city commission, but if I were to recommend and city council were to approve a reduction in line with what the city manager feels comfortable with, but instead of that typical 30-day period in which that was available to be taken advantage of by your client, if we extended that time out further to maybe give her time to get that property listed and sold, maybe that is a resolution. And I know you can't really speak up or down on it because, well, actually, you probably haven't discussed the extension of time with the city manager, but I can make a recommendation and he can tell the city council how he feels about it when they come to a meeting.
I think it would help, if that was what you're asking. If you could reduce it and we could get some time.
Can I say one thing on this property?
Go ahead.
This is a very unusual situation. It's in a mobile home park. The mobile home has since been demolished. One of them has deceased in just a few months. And the one sister that was living there has moved up north. So there is nobody even here anymore. That's why she is here. She lives in Tika Village and is a realtor, and she's just trying to help recoup with the demolition cost. So I don't know whether the city manager is aware of the circumstances, but I do want you to know that there is no home on this property now.
There's
It is
nothing.
just a lot.
Yes.
So
But the underlying violation was weeds and overgrown condition, correct?
correct, and there was a home there at that time.
Was it occupied?
Yes, sir.
To anyone's knowledge, were there circumstances that I should be aware of why why the violation continued as long as it did.
I can only tell you that the people that were there, they became very ill, and they have since passed.
The only knowledge I would have would be reflected in the letter from April of this year.
Do you remember the second case? You did see the people? Okay, with the roof caving in? Okay.
I can tell you, because I had an indirect communication with the city manager through city attorney Dan Manzares, that the amount that is in the proposed reduction is an amount the city manager is firm on in his proposal.
And that number was?
I get the sense that I would imagine that the city manager would be amenable to the 60-day if it were to be paid. I don't think that would be a tremendously.
Well, I was actually thinking beyond 60 days, and I was, because if
That I couldn't speak to.
I understand.
Sure.
I know I'm going to ask you a question
Sure.
that's beyond your authority to,
Sure.
to probably even comment on.
Yes, sir.
But I was thinking more along the lines of 6 months, because if it is the lien that's causing this property to be difficult to market, that certainly could be a problem, is a problem, obviously, for the respondent, but ultimately for the city either, because it sounds like the city, it's not as if the city particularly wants to foreclose. I don't know, I can't speak for the city council or the city manager, but this does not seem like a very good candidate for recouping through foreclosure. So a resolution whereby we can help them get it marketed, help them get it turned over, recoup costs, obviously, and some of that fine amount, and then the number that, Jack, tell me that number again that the city manager was able to approve.
9,602.20.
Okay, that's what I thought.
Yes, sir.
And that number is consistent with what I've ordered or what I've approved or recommended approval on other fine reductions, so I'm comfortable with it for that reason too, and being in the consistency of it. And where I would recommend beyond what the city is authorized to ask me to recommend, and again, the city council can do what it will.
Sure.
And to the extent possible, just this is for the realtor, to the extent possible, as much information as can be given to explain what occurred will be helpful when this goes to city council, because they will be curious about the similar kind of things I am, is why should I do this? And since they are the final decision maker, it would be very helpful to your client to get as much of that information to them as can be done. But that's the recommendation I'm going to make at this point, is I will recommend a reduction of the lien to $9,602.20, and that reduction amount to be valid for 6 months. If after 6 months it has not been paid, and hopefully it can be paid through a sale, but if in 6 months it has not been paid, the fine would revert to the original amount. I will say, given the circumstances of this, and I will actually include it in my order, just so the message is communicated up, how I feel about it to the city council, that, should the property be listed and not sold within that time, and there's an inability to pay it, and there are outside reasons why that amount can't be paid within the 6 months, I would not consider with any amount of, prejudice if there was a subsequent request, because I recognize sounds like it is a somewhat unique circumstance and difficult for all parties involved. But that will be my recommendation, and I'll reduce it to an order, and that way, when is it going to city council, do you know?
Probably the first meeting in June.
Okay. So that'll be out in plenty of time to get in the packet. Okay.
Mr. Magistrate, if I could, there is a companion case down on the
Yes.
agenda, the final item. In fact, if we could take that now,
That's
since
fine.
our realtor is here, which would be case 2020-1146, same property, same respondents. This was a proposal, again, the offer of the costs comes in that same April letter from Ms. Smart, I believe, yeah, Ms. Smart. The city manager has recommended an approved amount to resolve this. This was with the roof that collapsed. The total amount of accrued fine, $11,933.70. City manager has recommended a settlement amount for this of $1,403.70, which is within your full authority to approve if you deem it appropriate. So that's contained the city manager dated that May 13th of this year. Should be in your packet.
Okay, I will approve that one. It's consistent with prior reductions and agreed to by all parties, so I'll approve that and that
Yes, sir.
one. At the smaller amount, I will also go with what we would normally do, which is 30 days to pay, or else it will revert back to the original amount.
Yes, sir. Thank you.
Reduction of lien under 50,000. Case number 2013-176, Elmer Evora, owner, location of violation, 221 Georgia Avenue, St. Cloud, Florida.
Good dude. I might have misplaced my matter on this. Good grief. No, I have it here somewhere. So the final resolution, which with all my papers now, I seem to have misplaced. If you just give me one moment, please. Okay, I apologize.
He just signed it, right?
Yes.
Oh, wait, sorry.
Yes, sir, Mr. Magistrate. This was a case that was first heard back in 2013 and dealt with property non-sanitary condition and structure and not maintaining a structure, pool, et cetera. And the accrued fines reached $3,407.25. We have a letter, should be in your packet, dated May 10th this year from Mr. Elmer Evora, in which he was proposing to pay half of the amount accrued. The city manager has signed a request for reduction in which he approved the amount of $1,807.25, which I believe is the recovery of the cost, the administrative cost of $207.25, and then half of the $3,200 fine. So essentially accepting the proposal by Mr. Evora, but adding the administrative costs for an amount of $1,807.25 if paid within 30 days.
Okay, yeah, and I'm actually looking at that signed agreement by the city manager.
Oh,
and
okay, and I didn't know the response. It came in and signed?
He signed before I was sitting up here when he
Oh,
came in to
okay.
sign, so that's why
Okay.
I was asking the
Oh,
clerk
okay.
for the agreement.
Perfect.
Because since
That's
I knew it
right.
had just been signed.
That's
and
right. Okay.
There's one glitch in it, I think, that needs to be resolved, but, so, respondent, and if you'd like to, you don't have to worry, I don't have any questions for you, but if there's anything you'd like to tell me, you have the opportunity to. Okay. Based on the approval of the parties, I find the requested reduction is reasonable and will approve it. I think you'll have to sign the agreement again. It has a typo in it that the city manager and you will need to re-sign, and I don't know if you might be able to do that while he's still here. The clerk will help you do that while you're still here today. But I will approve that, and so it will be reduced to $1,807.25, which amount shall be paid within 30 days. If not paid within that amount of time, the fine amount will revert back to the original accrued fine.
New business, none. Next scheduled meeting, June 16th, 2021.
Anything else from the city?
No, sir.
We are adjourned.
¿Le entendió usted? Ah, ok. Hizo un error, so tengo que...